Good afternoon, everyone, and welcome to the second in our series, tackling issues for employers arising from managing in COVID-19 in the COVID-19 era. So I'll just introduce the speakers. I'm Joan Cradden, partner in the employment team here in Brodie's. Fiona Harrell, also a partner in the team, and Louise, who's a senior solicitor. We're talking today about flexible working in a COVID environment. And of course, that's really about home working and perhaps hours of work principally, because those are the arrangements that we know we're all becoming very familiar with. I'm going to look principally at how the arrangements are structured from a legal perspective and how you enter into them, and to some extent how you change them and deal with new requests that we think we're going to see coming down the line. Fiona's then going to move on to talk really about what businesses should be thinking about now in relation to flexible working, again, because of what we can see coming. And Louise is going to talk a little bit about the coronavirus job retention scheme, the support scheme, where we can see that there might be some interaction between flexible working arrangements and those terms. So moving straight in, Fiona said in her LinkedIn post during the week that this was going to be a protein bar rather than a 4-course meal. So I am going to rattle through the system that currently exists for managing flexible working, really with a view to getting you familiar, reminding you of what that looks like, and then moving into what we might be doing in the future with it. Just as a reminder, flexible working arrangements come about through two routes. You've got a statutory application that leads to a new contract, or you've got a contractual agreement that's outside of the statutory process. So if the arrangement's been reached through the statutory process, the terms are normally permanent, unless there's an agreement that they're temporary or there's going to be some kind of condition attached. It's more common in the current climate, obviously, for those changes to be temporary, and we all really know what the reasons are for the changes being temporary. The question that we're starting to come against already is, how do you change the arrangement? Employers are anticipating what they might need to do if they need to change the arrangements. The starting point is, did you make it permanent? Now, chances are you didn't if you've done it in a COVID context. If it's a proper formal flexible working application, you might have done. And if it has become permanent, if you want to change it, you have to go through the normal process for changing terms and conditions that are set out in the slide. If it was temporary, you can more easily revert to full-time working, obviously depending on, or working in the office, depending on how you explained your reasons at the time for entering into this new arrangement. In both cases, you're going to have to take into account the reasons given for employees when they object to you wishing to make that change, or indeed we'll come on to see when they ask for that change to be made permanent. So obviously, the watch points for us are, is there an obligation to make reasonable adjustments for a disabled employee, and does the employee have caring responsibilities? And we'll come back to that. Those are the two watch points when it comes to perhaps a bit of a tension between what the employer wants to do and what the employee wants to do, and where there might be additional legal issues arising. The recommendation, and this slide is really just for you to take away, if you're dealing with a change to an existing arrangement, follow the path that's on the slide. So what was the reason you entered into the arrangement? Do those circumstances still exist? Was the change permanent, or did you make it through the statutory framework? If it was temporary, did you make that clear at the time? Has the approach been successful? Can it be sustained? How did the business feel about it? And then how do you intend to respond in the event of a disagreement? And Fiona will talk a little bit more about how you solidify that in terms of a policy, but that's your path for dealing with objections. Very quickly, just to remind ourselves, if that's about changing an existing arrangement, what we think will happen is that you're going to end up with formal requests. When we all find ourselves in a position where coming back to work in an office looks like a reality, we think we're going to end up with a lot more formal requests. So here's a quick snapshot reminder of how flexible working requests work. So employees with 26 weeks or more service can make a request. They can only do it once in 12 months. It has to be in writing, it has to be dated, it has to mention the statutory rules, and it has to set out how they think the change that they're proposing will affect the business. There's an ACAS guide that you have to follow. You don't have to say yes, you have to consider it reasonably. You've got 3 months within which to do that, which is quite a long time. There's no meeting required, but generally ACAS recommend that you do have a meeting, and obviously you've got the question of a right of appeal or alternatively a grievance in the event that you say no. The penalty attached to refusing or failing to follow the process is quite weak. It's only 8 weeks salary, but we'll come back to whether or not that's really the issue, because frankly, it's not. When it comes to refusal, most of you who've dealt with flexible working requests will know that this statutory list of reasons for refusal is what we keep coming back to when we've got an employer who doesn't want to agree to a long-term change to someone's working arrangements. And the list is very vague. And I said at the bottom of the slide, please don't make the mistake of writing that list out and thinking that that's the end of the story. You have to explain exactly what it is within each of those categories you're really saying. So for instance, if you say that the working from home arrangement has a detrimental impact on the quality of the employee's work, you have to evidence that. You need to say why. You need to say why you anticipate it or why you've experienced it. Really coming on though to the nub of the next slide, please, the nub of the issue. I'm just going to kind of try and capture this, because what's happened is over the last few months, we've had a mini trial of flexible working arrangements all over the country in every employment environment you can think of. In the past, when we were giving guidance on the acceptance or refusal of a flexible working arrangement, we would normally have said, if you can't grasp whether it's going to work or not, have a trial. But we've had a trial, we've been living in the trial. So when we return to normality, lots of employees are going to have a very good platform for arguing that their home working has been successful, certainly from their perspective. And that is likely to lead, we think, to formal and informal applications. So if you're going to say no, you're going to be going back, whether it's statutory or not, you're going to be going back into those list of reasons for deciding on a refusal. But just to give you a little window in on what we're seeing, we've had dealt with some situations like this recently. And when we've whittled down the business's reasons for not wanting to say yes to someone's continued home working, the reason that they come up with is often communication. So they say, oh, I can't see them. I don't know what they're doing. I'm not sure what they're up to. Their output isn't as good as it was when they were in the office. And when you look back at the statutory checklist, it's actually quite hard to work out where to fit that in exactly without good evidence. So really what we're saying is you're going to need to start looking at this in a much broader sense and start developing your policy and your own perspective and the business's perspective on the way in which flexibility can work, and perhaps looking also at the attitudes that you might have among some of your line managers about whether or not it works and how you relate to employees when they're working from home. Final reminder, just from me, if the employee doesn't accept your position, your principal risk will be when somebody has got some kind of protected characteristics, so disability or caring responsibilities. Those are the two watch points when you're dealing with a refusal or a change. But what my big message is that whole trial that we thought we used to be able to pick off reasons from a trial for saying no or agreeing, understanding whether or not the arrangement was going to work. We've been doing that for the last 7 months, so expect those applications. And that really leads into what Fiona's going to talk about, which is the formulation of a policy going forward.
Thanks, Joan. So I thought I would start by saying sort of what should businesses be doing now? And we're acutely aware of the fact that HR teams are under immense pressure at the moment. You're dealing with and being pulled in so many different directions, from dealing with things like furlough, flexi furlough, the new job support scheme, thinking about employee well-being, supporting managers to manage colleagues remotely, and so on and so forth. And the list goes on and on. And so we're really sort of apologising up front for the fact that we're about to add to it. But we do think that flexible working needs to be on that list, and I'm going to talk about why we think that is the case. And in essence, as Joan has said, we anticipate there being an influx of flexible working requests once the current restrictions ease. And there have been various polls conducted about sort of the increased or continued demand for flexible working post-COVID. One that struck me was a YouGov poll of 4,500 employees, and there 81% of the respondents expected to work from home at least 1 day a week post-COVID, and 33% expected to work from home at least 3 days a week. So really sort of quite high numbers. And to put this all in context, even before COVID struck, there were plans to make flexible working the default position unless employers had a good reason not to allow it. And that was in the Queen's speech in December last year. And the government has also consulted on things like introducing a new duty on large employers to publish their family-related leave and pay policies, including flexible working policies, on their website, and also to include in gender pay gap reporting things like where jobs have been advertised as being open to flexible working. So I think the direction of travel is pretty clear, possibly accelerated because of COVID. But against that backdrop, it really does make sense to think now about this possible increased demand for flexible working within your business and to take the time to get ready for that. So you probably want to start with an audit of where your business currently is in relation to flexible working and to think about whether or not that needs to change. So you might be in an organisation where you've already fully embraced flexible working, in which case you might not have that much to do right now. But some of you might be in businesses where you have traditionally shied away from flexible working, in which case there's going to be a bit more work to be done. The policy is going to be absolutely critical here, conscious that not everybody has a flexible working policy, particularly if you are in a business that hasn't traditionally had much flexible working. If you don't have a policy, there is an ACAS code of practice, which is a statutory code, which means that an employment tribunal that's considering any case where there has been a request for flexible working and there's an issue in relation to how that's been handled, they will refer to that statutory code of practice. So that sets down sort of the bare minimum as to what an employer must do when they're considering a request, and certainly should be the foundation of any policy. But what we're recommending is that you go ahead and you implement your own policy, which is tailored to reflect your business, your workforce, your demands, your considerations, rather than having something sort of fairly generic that then doesn't give you the flexibility that you need when you're dealing with flexible working applications. Even if you do have a flexible working policy in place, it's quite possible that it's not been reviewed since COVID, and we think that that's something that should be happening now, or in the sort of short term at least, and we'll come on to have a look at the reasons why we're recommending that. When you're thinking about a policy, so either if you're drafting one or if you're reviewing an existing policy, here's some pointers that we think you might want to have on your radar. So first of all, what is meant by flexible working? I think in times gone by, flexible working has had like a fairly narrow interpretation. People have maybe used it to work part-time or maybe a little bit of home working. But I think what we've seen during COVID is that actually people are being quite creative with their working patterns and also with their place of work. So we need to be quite clear in our flexible working policy what we mean by flexible working and what's captured by this policy. So are we talking about a change to the hours that the person works? Are we talking about a change to the time when the person works? And or are we talking about a change to work from a different location? And of course, it could be some or all of those things. I think we also need to be thinking about what we say in our policy about statutory flexible working requests versus informal flexible working requests. So Joan sort of talked about those two different routes. Your policy will most naturally deal with your statutory flexible working request, but what about people who aren't eligible to make a statutory flexible working request but still make a request for flexible working? How are you going to deal with that? Are you going to click them in to the statutory process, or are you going to deal with them in some other way? The last thing you want is people who are not eligible to make a statutory flexible working request having a word with their manager and saying, is it okay if on a Friday afternoon I clock off early? And the manager saying, yeah, that's fine, no problem, no process follows. Whereas somebody who is eligible to make a request has gone through that process and perhaps it's dealt with in a different way. So consistency is going to be key. So having a think about that. One of the most fundamental issues we think is going to be multiple and competing requests. So as Joan says, at the point at which we can all return to the workplace, at that point, do we receive sort of a deluge of requests coming in for flexible working, and how are you going to deal with those in terms of volume, but then also how are you going to deal with requests from within the same team or department where there might be competing priorities? And so for that reason, because of its importance, I've split that out and I'll cover that in the next slide. Then thinking about what does your policy say, if anything, about requests to work in a different location. And again, this is something that's come to life, or to light rather, during COVID, that probably isn't in policies at the moment. And so, for example, you might have a situation where you have an employee who works for you in Scotland, but lives in, or originally comes from Yorkshire, let's say, as the example, and they've decided that because they're not required to be physically in the workplace, that they're going to return home to Yorkshire so that they're closer to friends and family, and able to see them, sort of subject to all the COVID restrictions. You might think at first blush that that's not going to matter, but of course we've now got different tax regimes applying north and south of the border. So there you could have a tax implication if the employee is working from home remotely from Yorkshire, but you're still paying or applying Scottish tax regime in relation to them. More drastic, of course, is people who want to go and work abroad, and we've seen cases of that as well. The Information Commissioner, for example, is working from Canada, apparently. But you can see there that there could be not just the tax implications, but immigration considerations too, as well as local law requirements, and then just the issues that we had when COVID first struck and people were stranded in the wrong place and we were trying to get them back, and we had quarantine restrictions, we had no flights, and so on. And so do we have to deal with things like that? So worth thinking about what you're going to say in your policy about those sorts of requests. And then what does your policy say about routes that are open to employees if they're unhappy with how the request for flexible working has been handled? The law doesn't require you to offer a right of appeal, but we would certainly recommend that you do offer a right of appeal as a way of trying to resolve situations where people are unhappy with the way in which their request has been handled. The last thing you want is people going all the way through the process that you've set out in your policy, including an appeal, and various different people having been involved in that process from a management perspective, and then the individual thinking that they'll effectively try and have a second bite of the cherry by raising a grievance, and then a grievance appeal, and so the situation goes on and on. So what are you going to say about that? In terms of your sort of multiple and competing requests, so there's no sort of obvious pecking order. It's not the case that people with different protected characteristics will out-trump other people with protected characteristics. It's also not the case, strictly speaking, that somebody with a protected characteristic gets automatic preference over somebody who doesn't. But of course, in reality, what you're going to be thinking there is about the risk profile. So the risk in relation to the person with the protected characteristic, who may well go on and bring some sort of discrimination claim against you, as compared to the person who doesn't have the protected characteristic. In terms of ACAS guidance, so this is separate to the statutory code that I mentioned, this is just guidance. It suggests that you look at each request on its merit in the context of your business, and that you don't apply value judgments about the most deserving request. I do think that has to be tempered with, but bear in mind the discrimination risk. That's probably quite a purist view. The ACAS guidance also suggests that you consider requests in the order in which they're received. And again, you can just see that that's pre-COVID, in circumstances where employers probably didn't receive that many requests at the same time. And so it was easy to sort of deal with them in the order in which they came in. What we don't want, or what I don't think we want here, is to basically have a race to see who can get their flexible working application in first, on the basis that they know that you've communicated in your policy it's going to be a first come, first dealt with type approach. And so people basically bashing out these flexible working requests without giving them proper consideration, just to make sure that they get theirs to land first, because that's going to increase the chances of it being accepted or approved. Some suggestions around whether or not a waiting list would be appropriate. So if you get to a part within a team or a department where you cannot physically agree to any more flexible working, whether you then sort of reject requests, but you keep those people on a waiting list on the basis that when things change, you will then go back to them and reconsider it at that point. I think all of these are sort of different options, but what you have to bear in mind is that the overriding requirement is to deal with requests in a reasonable manner. So however you're going to deal with this tricky issue and tackle it, that's got to be your underlying objective, is that you're going to deal with requests in a reasonable manner. And I'll hand over to Louise now, who'll cover the job support scheme.
Thanks, Fiona. I just wanted to make a couple of comments about the new job support scheme, which was announced by the Chancellor last Thursday. This will launch on the 1st of November and it will run for 6 months until April 2021. It's designed to protect what's referred to as viable jobs in businesses facing lower demand over the winter months as a result of coronavirus. And it's intended to essentially be the replacement for the furlough scheme, which is coming to an end on the 31st of October. At this stage, the government has published a 4-page fact sheet, but it's anticipated that more detail will be published in due course. But at the moment, what we know is that under the scheme, the employee must work at least 33% of their normal working hours, and they must be paid as usual by their employer for working those hours. For each hour that isn't worked by the employee, both the government and the employer will pay a third each of their usual hourly wage, and the government contribution will be capped at £697.92. We also know that employees will be able to cycle on and off the scheme, and they don't have to necessarily work the same pattern each month. But short-time working arrangements must cover a minimum period of 7 days. So the government guidance expressly states that employers must reach agreement on the new short-time working arrangements with their staff, make any changes to the employment contract, and they also have to notify the employee in writing of the change, and that agreement must be made available to HMRC on request. So if you've had employees on furlough or perhaps more recently on flexible furlough, you're going to need to bring those arrangements to an end and put new arrangements in place. And the reason that we mention the new job support scheme as part of this webinar is because in order to utilise the scheme, the employee must be working less hours than they ordinarily would be. So it is just another form of flexible working and something to be aware of.
Absolutely, thanks, Louise. I think we've rattled through that amazingly quickly. So we've got time for questions, and we've got, I think, quite a few. So I think the first one that's come up, I'll just pick it up, is a question about agency workers. I think I made the point that agency workers are not covered under the flexible working scheme application, the statutory scheme. The answer to the person who's asked the question, which is really about, how do we handle it in the context of agency workers, is you talk to your agency. You need to have a dialogue with the agency themselves to work out a system for dealing with applications. The chances are, agency workers are almost by definition in more flexible arrangements and on more flexible contracts. So that of itself shouldn't be the issue. You do need to talk to the agency very specifically about workers who might have a protected characteristic such as a disability. So the recommendation there is a good dialogue with your agency is what's recommended. We've got a question which was, is an employee who's at high risk of contracting or COVID causing them serious health issues, they're always going to have a reason to stay at home? And the answer to that is it depends. So that is really a reasonable adjustments question rather than a flexible working question. And obviously, a disabled employee who's been working successfully at home for a long time now may well be in a very good position to argue that allowing them to remain at home is going to be a reasonable adjustment, and may be a reasonable adjustment for so long as COVID would continue to pose a risk to them. And I think we've got quite a lot of employers who find themselves effectively accepting that as the position. Other question, anybody else want to pick up a question?
I think, Joan, there's a question about sort of the challenge of management who are maybe not quite there yet in terms of accepting that flexible working, home working in particular is the sort of the way forward. And I think we recognise that is a challenge within some businesses. I think HR's role there is to educate, if possible, to perhaps do some research in terms of this various studies. So this is not just us as employment lawyers or you as HR professionals saying this is what we think might happen. I mean, this is against various studies having been undertaken, various surveys having been conducted, and overwhelmingly people are saying, actually, this has worked well for me, and I think that I would like this to continue going forward. But also some businesses reporting that actually they've seen an increase in productivity, an increase in employee engagement, because you're not having to do that horrific commute, or because they're not having to do the sort of mad, stressed school dash run and then get to the office for a particular time, all those sorts of challenges. So I think it's about sort of if you're in that situation where you're sort of being the advocate for flexible working, doing your homework in terms of pulling all of that together to say, look, this is not just an HR saying this would be a nice thing to have, this is the direction of travel. And I think there's also a risk that if you don't and your competitors do, in due course, once this just becomes the norm in many workplaces, actually you'll be left behind from a sort of talent attraction and retention perspective, because you'll be the ones who are perhaps stuck in what is then seen as the sort of old days, and haven't embraced this change. So I think that's what I would be recommending there.
No, that's right. I mean, it goes to some extent as well to my point about communication, because I think what we find is that where the home worker, flexible worker is measured, or their output is measurable, we find that there are fewer issues. Where it's more difficult to measure someone's output, where they may be doing things that take longer, it may be that may be the situation in which you see more objection from managers, because they don't have visibility. They can't see what somebody's doing. They can't see what they're doing on a day-to-day basis, and they don't see the output literally. But that's a management question. That becomes a management question as opposed to a question for the employee. If the employee isn't doing their job well enough, they need to be told. And if the managers can't articulate that, then that presents HR with the difficulty when it comes to fighting back a request for flexible working. So yeah, I agree, that's absolutely right. Okay, so any more questions? Can you explain who would not be eligible to make a statutory flexible working request? The only people, so the people who can't make it are people who are not employees and who have less than 26 weeks service. So those are the only people who cannot make a request. So in other words, we're way past that world where we had far more restrictions on who could ask. Effectively, anybody can ask for flexible working now. And that was very much, as Fiona said, very much in the government's thinking recently about the way in which they wanted to see workplaces evolve.
I guess the only additional person there would be somebody who's made a request within the last 12 months. So you could have a situation now where somebody has made a request for flexible working pre-COVID, and then their world has changed because of COVID, and they now want to make another request, but it would be within 12 months of the last request having been made. Strictly speaking, under the statutory regime, they're not eligible to make another request, but you might decide that actually their personal circumstances mean that you are going to have another look at it, because it's, you know, the world is completely different to how it looked at the point that they made their request pre-COVID.
Mm-hmm. Just a couple of questions on that. The question of employees working from abroad. We've actually dealt with that quite a few times now, and we know that there are some large employers who are taking a view on that and deciding to say no across the board because of the complexities that it can create, that Fiona alluded to. So it's probably worth you knowing that, you know, saying no to that is not out of the question. Obviously, there may be circumstances where you decide that it's sufficiently important and not enough of a retention tool to mean that you will allow it to continue. But there are employers, particularly the larger employers, who've decided that it's just too much of a headache to allow it to continue, certainly at the moment.
And I think the point is you need to know, don't you? Because you can't manage it from an employment perspective, from a tax perspective, from an immigration perspective, if you don't know where the individual is, which is why I think calling out in your policy that working from a different location, including overseas, falls within the scope of the policy. So that people realise that it's not just a case of saying, oh, I would quite like to work from Portugal for the next 6 months, so I'm going to disappear off there and rent a house and live out there for the next 6 months, and it won't matter because I can log on and I can still do my work, so it doesn't really matter to my employer where I am. I think the point is it does matter, and we need to know where our people are so we can make sure that all of those considerations are being factored in.
That's right. The one very quick question, basically, which is a very common question. Employee wants to work restricted hours. We have things that they have to do outside those standard working hours. How can we accommodate a flexible working request in that context? Well, you default to the statutory reasons for refusal in that case. If you have a requirement that employees work outside of the hours that they're suggesting, and you can demonstrate that that's the case, then that would be the basis for your refusal. And assuming there's nothing else in play, like a protected characteristic, that should be a basis for refusing the application. So I think we're probably coming to the end of the session. We hope that was been useful. We're more than happy to continue a dialogue with anybody who has got any particularly burning questions that we didn't pick up. That was a whistle-stop tour of the things that are coming. I think the message is clear. Please think ahead, because we can see this coming down the line, and we know that you're going to need to be ready to deal with it. Obviously, we will more than happily provide you with some guidance in relation to the policy development, which Fiona was talking about, if you'd like to get in touch. But thanks very much for attending.